Hello, everybody. I'm Kristen Van Sweeten, and I'm very happy to be able to welcome you today to the first of what we plan to be a series of talks on the subject of the treatment of COVID-19 induced or COVID-19 related bankruptcy or insolvency. This series of talks is part of a wider project that I'm doing at the University of Oxford together with two of my colleagues, Professor Oren Sussman and Professor Horst Eidenmuller, who of course is chairing today, the title of which is COVID-19, Public Policy and Commercial Law. The purpose of this project is to try to understand and then to critically evaluate how policymakers have responded to a wave of business bankruptcies associated with COVID-19 trading disruption. So at the first initial conceptual stage of this project, we considered whether there was a case in principle for a policy response. And having established this case, we turned to chart in theory how policymakers might respond. So what the set of options were that were available to policymakers. And we also sought to discern in a preliminary way what some of the principles that were relevant to choosing between this set of options might be. And that first stage produced a working paper which is publicly available on SSRN. We're now in a more empirical stage of the project, in which, with the help of a team of very talented researchers, we're seeking to collect evidence of policy responses across a large number of jurisdictions. And to supplement this evidence gathering work, we are also holding a series of talks, of which this is the first, in which experts from the relevant jurisdiction offer their reflections on the policy response in that jurisdiction. So this, as I said, is the first in this series. Our jurisdictional focus today is Germany, and I'm very happy to hand over to my colleague Horst to chair the discussion with our panel of eminent speakers, and I look very much forward to the discussion. So thank you, Horst.
Thank you, Christian. Good afternoon, everybody. Welcome to today's event, Supporting Distressed Businesses During the COVID-19 Crisis, the View from Germany. Before we discuss the various issues that we want to discuss, let me just briefly sketch the background to this event and why we think it is helpful to look at the German response. Now, the next three slides tell you a little bit about the economic story associated with the COVID-19 pandemic. This slide shows the decline in GDP in the first quarter of this year in the EU27, in Germany and in the UK. You see that the crisis was already unfolding to some extent, but the really big hit happened in the second quarter when the UK's economy dropped by almost 20% compared to the prior quarter. Germany did better, as did the European Union. In fact, Germany did better than the average of the European Union member states. Now, in the third quarter, the situation improved slightly. From the perspective of all member states and the UK, the UK economy did better by 15% compared to the previous quarter, Germany 8%, the European Union 27%. Now, if you add up all these figures and try to assess the cumulative effect for the first three quarters of this year, you see that the UK economy shrank by approximately 7%, whereas Germany's economy did better, comparatively speaking, with only a shrinking of 3.5%, the EU 27 3.1%. So that makes Germany an interesting case, especially from the UK's perspective, in terms of understanding what kind of policy measures were implemented to help COVID-19 distressed businesses. Now, what is the German policy approach? The speakers are going to look at this in much more detail in a minute. And I would like to just set the scene by giving you a high-level perspective on what has been going on in Germany in the last months. The basic goal one of the basic goals of the German policymaker was to keep COVID-19 distressed businesses outside bankruptcy proceedings. And that was achieved by a combination of measures, a suspension of filing duties, which is supposed to come to an end by the end of this year. I'm going to say about something about this in a minute, and massive cash flow assistance for businesses by a scheme that involves guarantees, loans, grants, etc., in the order well beyond 100 billion euro and maybe even going close to 1 trillion euro, both for SMEs and large corporations. These are enormous sums, of course. And many will recall that the German airline Lufthansa was bailed out a couple of months ago with a sum close to 10 billion euro, and the German state indirectly taking an equity stake of 20%. Now, another interesting measure that was adopted was that termination rights with respect to rental and lease arrangements were temporarily suspended, also in an effort to ease cash flow problems for distressed businesses. Now, in tandem to trying to keep distressed businesses outside bankruptcy proceedings, the German lawmaker has been and is working on modernizing its restructuring laws, its formal restructuring proceedings based on a European directive which requires the German lawmaker to do so. And the new law is supposed to be coming into force when the suspension of the filing duties ends by the 1st of January next year. Another interesting feature of the German response that we are going to discuss is that there was and is the clear goal to maintain current employment levels by broadening the scope and access of the existing furlough scheme. In fact, the German furlough scheme was kind of the role model on which many other approaches of the similar nature in other European member states and other states around the world have been based. Now, finally, the picture wouldn't be complete without me at least mentioning that in terms of macroeconomic policy, an interesting measure was adopted that aimed at stimulating consumer demand, namely a temporary reduction of VAT from 19 to 16%. Now, here are a couple of questions that we should like to put to our speakers and that they may or may not, when discussing these various issues, touch upon, and you from the audience might pick up later on in the Q&A as well. So as you all know, there is not just a UK or a German response, there's also a European Union response to the crisis. The question here is, do you feel, the speakers and you, that these responses complement each other well? Secondly, Germany is a federal state, so measures have been adopted on the state level and the federal level. What I've discussed so far has been done on the federal level. What are the differences between measures at the federal and those at the state level? And are these measures, or have they been aligned well? More generally speaking, which measures have worked, which have not worked? And if you were a policymaker with decision-making authority right now, what should be done? What should be done now? Fourth, a key issue with respect to policy measures is, of course, filtering COVID-19 distressed but viable businesses from others that actually should be liquidated. Has that been done well in Germany? Has moral hazard been contained or not? Fifth, what about long-lasting changes to German commercial law? Do you foresee such changes? And if so, will these be for the better? Finally, sixth, what about your restructuring practice? We have very distinguished practitioners speaking today and also in the audience. What is going to happen to your restructuring practice? Is it changing already? And if so, in which direction? Now, these are questions that one may have in mind when thinking about the issues that I've touched upon. And we have a distinguished set of free speakers to address these issues and the questions and others. And we are going to go step by step. Christina Weidner from Clifford Chance is going to start off, followed by Christian Herwig from Hogan Lovells, and then Stefan Madaus from Halle University is going to be the one who sums it all up or tells us where the others have gone wrong and why they're wrong, in true professorial style, of course. Each speaker has 10 minutes, and we are going to make sure that these are not exceeded, because we want you in the audience to put questions, and we want to have enough time to debate these questions. Now, Christina, the floor is yours, the virtual or online floor.
Thank you very much, Christine and Horst, for this introduction, and thanks to everyone for joining the session today. My name is Christina Weidner. I am a restructuring expert at Clifford Chance in Frankfurt, and I would like to spend the next 10 minutes to talk about some of the measures which have been implemented in Germany, and they have been on your list, Horst, so I'm very glad that you included them. And I'm going to talk about the suspension of insolvency filing duties and the new restructuring framework, which is currently being discussed and a plan to be implemented as of next year in Germany. So on these two different measures, I believe that, of course, over the last months, we have seen the impact of the pandemic on all industries suffering from declining demand. And the obvious ones are tourism, casual dining, leisure, but also machinery, plant production, and steel industry. And a variety of measures have been put in place in Germany, and they certainly work in tandem and as a combined mixture of different measures. But my personal view is that amongst the most efficient measures, there are certainly certainly the large amount of liquidity, which has been injected through the different state aid measures by the German government, and the suspension of the insolvency obligations. Let me start with the suspension of director duties. This was crucial at the beginning of the pandemic in March 2020, because it was necessary to give the company sufficient time to access the liquidity measures and to give the authorities sufficient time to process the applications. And as far as illiquid businesses are concerned, we are now in Germany back to normal since October the 1st, which means that companies which have not succeeded in ensuring their solvency over the last 6 months, and despite the multiple state aid packages which have been available, these illiquid businesses, as of the 1st October, have to withdraw from the market again, just in order to ensure that there is again confidence in the economic cycle. And this is definitely the right step in order to prevent damage from creditors by operation of illiquid businesses, and to also prevent unfair competition in the German markets. For companies without a positive going concern, they still benefit from suspended insolvency filing duties until the end of 2020. This is the current plan. There might be a further extension in this regard. For those who are not familiar with the German insolvency regime, the over-indebtedness is an additional trigger for insolvency in Germany. So that's a mandatory reason to file. It includes a balance sheet tests and a forecast on the going concern. And this will probably come back into force as of next year again. And the latter insolvency trigger, the over-indebtedness, is really problematic in times of COVID-19, because there are hardly any industries which have not been hit by the pandemic. And for these companies, it is very difficult to maintain a going concern and to demonstrate that these businesses are funded through over the current and the next financial year. So, which is the test according to the current law, and the legislator is planning additional changes to this solvency test. But under the current circumstances, with the pandemic still ongoing, I personally believe that there is hardly a company within the industries I have just mentioned which would be currently in the position to demonstrate that there is a sustainable and long-term going concern, since I believe no manager has a crystal ball. So it might have been better to consider to simply remove this additional insolvency trigger. And when we're talking about measures which have worked and which haven't, in Germany, I believe we discussed removing over-indebtedness for many, many years. And I mean, there aren't many jurisdictions which have similar insolvency triggers, yeah? And in practice, it may not even be a real trigger for insolvency, because most insolvencies are being filed on the basis of illiquidity, but not on the basis of over-indebtedness. So, but anyways, I believe, leaving this discussion aside, there are also voices in the German market who are generally very skeptically looking at the modification of insolvency triggers. It can be used as a quick fix to overcome a crisis over a relatively short period, but from a long-term perspective, it is somehow counterintuitive because it's not perceived to be sustainable. With all the liquidity measures which are currently in place, we have basically produced an army of companies limping around in the twilight between the living and the dead. And we are looking at a decade of low interest rates in Germany, which had already sustained the rising number of companies that were not able to borrow, that borrowed cheaply and basically fell short on the interest needed to pay to their lenders. So, and I do believe that COVID-19 has definitely accelerated this trend and given rise to a new generation of corporate zombies. So there is an element to this where probably insolvencies, they bring valuable adjustment to the markets, and we should be careful with sunshine insolvency regimes, which only apply in good times. This may certainly not work in the long run. Leaving insolvency duties aside, there is another initiative of the policymaker, which involves the German draft bill for a preventive restructuring framework. That includes the German Stabilization and Restructuring Act, called STARUG in Germany, which might be implemented as of 1st January next year. It might also be delayed because there are currently a lot of open points which are still subject to discussion, but it is a good step in the right direction. We've been discussing in Germany, I believe, for years, whether we actually need a preventive restructuring tool, despite the existing insolvency proceedings and in-court restructuring tools which we have in Germany. And we discussed whether these are sufficient to encourage early restructurings and to preserve values and maintain businesses at a going concern. We are now seeing that the implementation of the European directive to harmonize restructurings in Europe generally, we're now seeing that this implementation into German law is currently, under the current market conditions, inevitably also driven, whether directly or indirectly, but it is also influenced by the current environment and the desire to make this process as efficient as possible to allow businesses to restructure in the context of COVID-19. So this is basically something, we don't have a comparison scenario, but I do believe that the implementation itself is hardly driven also by the pandemic, because the legislator has and is incentivized to enable restructurings, and the current proposal is very, very debtor friendly with large discretion rights for debtors in terms of what they are presenting as restructuring options. The creditors will have very limited options to influence that proceedings and the content of the restructuring plan to contribute to the process. unlike a scenario which we would be seeing, for example, in a consensual restructuring scenario. And creditors can, of course, not stop this restructuring process, because that's actually the goal of the entire restructuring framework. And the way it is structured, it's actually meant to prevent holdout position and to capture all stakeholders, including shareholders, into these proceedings. And it's actually, it is a very great step in terms of for the restructuring landscape in Germany, and this will be amazing to have such proceeding in Germany. And for us at Clifford Chance, I think we have for many years also restructured companies in front of English courts by using English scheme of arrangements. So we have for a long time also been waiting for such proceedings, early preventive restructuring frameworks to be implemented in Germany. But at the current stage, it looks like there are many open points and still points for discussions. And this might also be a reason why we may not have the proceedings at the beginning of next year, but later on in the process. And Christine, I'm now watching the time. I think I could continue, but I wonder whether 10 minutes have elapsed already.
They have indeed, Christina. Thank you so much for your introductory remarks. Before I hand over to Christian, I should like to ask you one question. Now, you discussed the issue of filing duties, and you said that under German law, there is a filing duty if the company is either cash flow insolvent or if it is insolvent based on a balance sheet test. And you argued that the filing duty with respect to the balance sheet test is problematic for various reasons. At the same time, you have been saying that because of all the cash that is flowing around, quote unquote, we might see a lot of zombie firms as an outcome of the policy measures that have been adopted. So I wonder whether there is a tension here in what you have been saying, in the sense that the filing duty with respect to balance sheet insolvency might be one of the last resorts to make sure that the number of zombie firms is kept in check. And if we do away with that filing duty, we might create more zombie firms than necessary.
Yes, that's a very good question. I mean, I should have probably spent more time to elaborate on the actual trigger for insolvency on the basis of over-indebtedness, because at the end of the day, it is not the pure undercapitalization which would trigger the insolvency filing, but it is always by including the going concern prognosis, it would always be a liquidity-driven analysis. So it basically comes down to the question whether or not the business has sufficient liquidity over the prognosis period, which is currently the current and the next financial year, but it will be adapted to 12 months going forward, and or even 4 months for COVID cases. Having said that, it means in the end that the pure undercapitalization and over balance sheet over indebtedness will probably never trigger the actual filing, because it is a liquidity-based analysis. So we will probably continue to see zombies running around, if I can put it that way, as long as they do have sufficient liquidity. So they would probably have too much debt on their balance sheet, but would be able to continue to operate. This would be at least in line with current insolvency law in Germany. So I think it needs more, not only insolvency triggers, it needs more in order to right-size the balance sheet of these companies again, and to right-size the debt, and to make businesses sustainable again. And I think the new restructuring framework is definitely the right step into the right direction, but it should ensure that it is a balanced approach, and that it would be, for example, there are a lot of open points, such as the standards which will have to be applied in terms of documentation to be provided by the debtors. The question is also, these proceedings, will they be available to mid-sized companies or to individuals, entrepreneurs? Would that probably cause major problems with the resources at our insolvency courts? That might be a serious issue if we basically flood the courts with this process as of next year. So there are a lot of points to be discussed, but as a step to enable early restructurings and to encourage early restructurings, it is a good step into the right direction.
Thank you for clarifying. So, Christian, it's your turn now, and we're curious to listen to your perspective on the German responses.
Thank you, Christine. Thank you, Christina. Thank you, Horst, for the overview and the initial thoughts, and hello, everyone, to this panel on this webinar. I'm Christian Herwig. I'm a partner in the financing and restructuring and insolvency practice at Hogan Lovells in our Munich office. And in that role came across Christina, obviously, a couple of times on interesting projects. So yeah, good to see each other again here. Horst, one of the questions you raised was, did the policy responses to avoid COVID-19 related insolvencies in Germany work? And I think, at least for the time being, the answer to this question is yes, it worked. However, it comes at a price, and some policy responses work better than others. Let us maybe start to have a quick look at some slides. Let me see if I can share them here. I think the initial slide, Horst and I had the very same idea to start having a look at the GDP. So I don't have to go into details here because you've already mentioned that here, how the GDP went down significantly in Germany in the first 2 quarters 2020. An interesting slide to look at in parallel to that is the next one here. And that is the number of insolvencies that indeed at the same time went down. One would normally expect, of course, when the economy goes down significantly, that insolvency goes up. But here kicks in what Christina has already talked about, i.e. that the obligations to file for insolvency were suspended. So the answer is less insolvencies indeed. But again, this comes as a price, and one of the key issues here is to look at our fiscal policy. I think there was a very balanced fiscal policy over the last couple of years. I've just, as an example, shown the 2019 figures here, where you can see that there was a positive balance of income exaggerating the expenditures by 13 billion. So this has dramatically changed as it currently stands in 2020, where we can see this balance is decreasing to a negative balance of more than 200 billion. So this is really an amazing development that is clearly triggered by all the investments that the state has made, being the short-term employment that is basically state financed, or guarantees or other liquidity support, financial support given in the last couple of months. We have mentioned already here the so-called zombie companies, which is something I would also like to focus on. These are companies that cannot shoulder the debt burden from their operating profits and are only kept alive, if you like, artificially by cheap loans. And such zombie companies continue to participate in commercial life, even though they have, in fact, no right to exist on the market. And by supporting such zombie companies, I think there is a lack of an economically necessary selection on the market. And of course, market selection is absolutely essential to ensure that insolvent or over-indebted companies do not infect solvent market participants doing well, but not knowing that these zombies are in fact already kind of close to death. In fact, what happens is the contracting healthy parties thus expose themselves to the insolvency risk of the damaged companies. So solvent zombie companies are increasing the competitive pressure on healthy companies that have to cope without government assistance. So this too can lead to an initially solvent company becoming distressed. On that background, if I had a magic wand, my proposal would be, with a view also to possible bankruptcy wave and the creation of zombie companies, to, I think we should have had a shorter term of suspension of the obligation to file for insolvency, in particular with regard to the over-indebtedness, which has now been extended to the end of the year and may even be extended until a later point in time, in case the new restructuring law will become effective not as of 1st of January, which I think is currently unclear, but at a later time. And at the same time, if I had that magic wand, I would have wished we had an earlier implementation of the European Restructuring Directive. So, thing is, I mean, I am aware of the complexity of the like stabilization and restructuring framework, also referred to as the German Staruk scheme the other day. I like that name. It's something with scheme, and I think it really describes what it is. And I am aware of the complexity. I think government put on our desk a more or less 250 pages document, including all the reasonings behind the new provisions. And all stakeholders, of course, plus the German insolvency courts, have to understand the new law. And that does take time. However, our neighbors, for instance, in the Netherlands, managed to be a lot quicker than we were. And they have already implemented the EU Restructuring Directive under the so-called VOHA by Parliament on 6 October 2020. And I think in the current situation, and in particular to prevent zombie companies acting here on the market, it would have been fantastic to have already that tool at hand. And I fully agree with Christina that this is a very challenging and interesting work that is coming up here for many participants, but obviously for big law firms as Clifford & Hogan Lovells, of course, will provide excellent opportunities to help clients in completely new ways. You've also asked in what ways we think that the policy responses to COVID-19 will change the operation of commercial law in Germany, and are they for the better or for the worse? And I mean, currently it is hard to say to what extent it is the policy response to COVID-19 or the general implementation of the EU Restructuring Directive that changes the operation of commercial law going forward in Germany. I suspect that COVID-19 and the related huge demand for an effective restructuring framework clearly influences the way the EU Restructuring Directive is implemented. In a way, it is, of course, a coincidence that COVID-19 occurred more or less exactly at the same time, or occurred more or less exactly at the same time when the jurisdictions in continental Europe were considering how to implement the EU Restructuring Directive. So you will recall that the EU Restructuring Directive provided many options which could be implemented in one way or the other. I think more than 70 different options were in there. So it seems to me that COVID-19 has indeed helped German government to encourage coming up with a more restructuring friendly approach. And let me just give two examples. We've already briefly mentioned the over-indebtedness and impending illiquidity as two of the three grounds in Germany to file for insolvency. And the relationship between the impending illiquidity and over-indebtedness has long been a bit of problematic. Both require a future-going concern forecast. Both reasons for application regularly cover the same facts. And under the new restructuring law, this problem would worsen considerably, because only in the event of impending illiquidity will it be possible to reorganize at an early stage by way of new restructuring plan. Therefore, there needs to be a clear distinction between impending illiquidity on the one hand and over-indebtedness on the other hand, which is envisaged under the new German proposed German Staruk scheme. So here you can see what the relevant time frames here are. Over-indebtedness will go in the future be looked at for the next 12 months, and whereas impending illiquidity will have a relevant period for 24 months. So this is already helpful. I'd like briefly to mention another aspect, and that's the new obligations for management directors under the new law. There is a fundamental change for managing directors coming into force with the German Staruk scheme, because what happens is that directors of a company which is in a state of impending illiquidity will have to protect the interest of the general body of creditors. So even the members of the supervisory bodies will monitor compliance with such obligation of directors, and directors who breach their obligation to protect the interest of the general body of creditors in such a situation will be liable for damages incurred. So this is a major change in relation to the directors' duties. For the first time, the management is also obliged to the creditors at an early stage of a distressed situation. So the directors will find themselves kind of struggling in between two forces, the creditors on the one hand and the shareholders on the other hand. And clearly that won't make their life easier, to say, put it like that. Quite frankly, I wouldn't even want to be a managing director. I think as of 1st of January or March, it'll be a really hard job for them. But in any case, from a pure restructuring perspective, I would say, looking at, for instance, debt for equity swap structures and the like, I think the approach will indeed be very helpful for a successful restructuring. And with that, I like to hand back to Horst, or hand over to Stefan for the academic view. Thank you.
Thank you very much, Christian, for your presentation, especially on the issue of zombie firms that we talked about already and the new German restructuring law. So if we add these two things up, what we can expect then at some point in the future, probably rather sooner than later, is a massive crash test for the new law once it comes into force, because thousands and thousands of firms somehow will end up in this new framework. Now, if you assess the framework as it has now been proposed, do you think it is in principle well designed, or is there something that you would like to tell the German lawmaker in Berlin right now that they should change in terms of the architecture of the new law, so that the crash test doesn't lead to a massive disaster at some point?
I think your outlook to the future is exactly right, and probably Christina, you can confirm that we are all warming up here internally to get up to speed with the new law. We are already having certain cases in mind which we hope will survive until the new law is finally implemented, so that we can make use of it. And there will be huge opportunities, I think, because we have a number of companies or clients that indeed they do have some, say, potential shareholders who keep them alive, so they pass the liquidity test at the moment, but you may have doubts on their going concern prognosis. That is hotel chains, or I don't know, everything in the traveling area, like most importantly, of course, the airlines and so on. Anyway, so they're all probably good candidates for the new law. Is it well done or not? Quite frankly, I think the overall view from what I hear, also from colleagues here in bigger law firms, is that the approach of the German legislator here seems very well done, and is being very well perceived, I think. So because it does indeed offer very strong restructuring possibilities. Most importantly, we have tools in there, like in the where other jurisdictions have made very good experience with, like Chapter 11 or in the US, or the scheme in the UK. So most importantly, you have automatic stays, you have moratorium, you will have the cross-class cram down, a very important tool. There will be the opportunity within one group to cram down creditors in the same group with a 75% majority. So that's all very, very promising, I have to say. And even some additional improvements have been made recently when the new revised draft came up. One thing I'm not quite sure if that's probably addressed there is the fresh money issue. So this is fresh money is an important tool in the US Chapter 11. And here, I think with fresh money and having some kind of super seniority to be implemented in the new law, that is something I think where the law could probably be improved.
Thank you a lot. I hand over now to Stefan, who is going to tell us whether the new restructuring regime is great because it is a great new toy for Christina and Christian, or whether it is really great because it is a fantastic tool also from a scholarly perspective.
Thank you very much, Horst. To answer this question first, of course, it's a great tool. This is a German panel, and you will not hear much different here, especially not from my side, who was a long-time advocate of this kind of modular tool. And I think it came up well designed. You might find some doctrinal flaws in it. I'm not sure that it is well founded on insolvency principles, but the tools themselves and the way that they are designed, they should be very effective, quite efficient, and in the hands of a German court, I hope they will work well. In my 10 minutes, I would like to do a little different thing, because much has been said already, but some has not. In my view, there's a lot of good things. If you look at Germany, obviously, by statistics, it shows that we do well, quite well at least. But there's also some dog corners, and I'd like to focus now on the dog corners if you want. Because by far nothing is working perfectly in Germany, and it might fall back on us depending on how things will continue. So first things first, I think we need to distinguish 3 steps in the COVID response, and or 3 stages if you want. And we did well, and we do well in Germany on 2 of them, but we do quite poorly on the 3rd. So if we look at the 2 we do good on, they were mentioned extensively already. So we have the emergency stage. When COVID arises, markets freeze, governments go into lockdown, courts go into lockdown. You need an immediate response to a situation where there's a lot of turmoil and uncertainty, and bad weather law is needed. And we did a very good response in that respect. So we had, as many other jurisdictions did as well, made the very specific decision to avoid bankruptcy, because bankruptcy would be unfair to businesses in that situation who get hit by that situation, and who would trigger insolvency tests of good weather insolvency law in a situation where 1, they're not justified, and 2, they wouldn't lead to anything because the institution and the market isn't there to handle insolvencies in the first place. So on what market do we drop those businesses in insolvency if you want to have a market or a going concern test? So it was right to suspend duties, and it was right to suspend them in a far-reaching way. It was right to support immediate steps taken to include something like a moratorium for the initial step, and to secure funding through state funding, but also to support private funding of companies and businesses by extending privileges in case there's a subsequent insolvency. So this first step was very strong, very good, very immediate. And together with a colleague, I highlight that also in a paper that was published in September in the European Corporate Financial Law Review. The second stage we did well was basically the 3rd, which is good weather insolvency laws. Of course, you need efficient good weather insolvency laws, and by implementing the directive the way we will do, and by also updating our insolvency laws based on an evaluation that has been done and pending for a couple of years now, we actually were lucky in Germany because we were ready to improve not only our insolvency laws, but also our restructuring laws, and maybe fill a gap that we had in our legal system because we haven't had a preventive restructuring framework at all. So you might say that this was luck and timing because we were prepared. We had a prepared reform for both sides of insolvency and restructuring laws, and we can implement them now, maybe accelerated, of course, by the situation as we have it now. So we have improved good weather insolvency laws. Right, I can only agree. I like the reforms as they are now discussed. There's a lot of noise still. It's a political process. But I think in the end, it will be a good new remodeled German insolvency framework and restructuring framework. And now let's come to the dark side. The dark side is very, very clear. It's the in-between. We had an immediate response that was good. We have a good weather response that is good, but we're not anymore in the insolvency stage, in the emergency stage, and we're not yet in the good weather stage. So we're in an in-between pandemic stage, and no one's really having a clear idea of how to deal with it. There is good reason to keep to emergency measures because for some in the market, there is still an obvious emergency. And there's good reasons to think things have come back to normal for many others. Markets have come back to normal. Courts are back to normal mostly, even if they move to home office again, but now they know how to do that. So it's not something like an interruption anymore. So we have a new normal, but we need laws for this new normal. And the only thing we have is the old emergency laws extended to a certain period of time, and a discussion whether they should be extended again and to what extent. And we have a good weather law that should now come into force early, but we don't have good weather yet, at least not for those businesses that are still struggling from COVID. So the German answer at the moment is to keep funding public money. So we try to provide everyone with liquidity, and the basic idea is to, avoid insolvency proceedings still for as much as it is possible or justifiable. And there's another issue there. One is for how much longer can we do that? So we extend public funding programs for companies, which makes them not hit the triggers that are back in force, of course, at least most of the triggers. So you keep them liquid. Liquidity is still there. You create zombies if you want, because they are running on liquidity that is often state provided by the state. But of course, it will hit an endpoint at some point. So currently the German government is kicking the can down the road, hoping that there will be an end to this intermediate stage at some point early next year or mid next year, or at least before the election, because the next big thing you have to remind yourself is that we have a major election in September 2021, and no one wants to see insolvencies go up in the immediate foreplay of an election. That's really bad timing for everyone involved now in the decision-making process. So we will keep funding furlough schemes. We will keep funding this kind of programs until at least September 2021. That's been decided already. So the big question would be, what happens after that? Will we keep funding this or with a deficiency budget, or will we start looking at something else? The second dark corner is that we are doing quite good in funding the German Mittelstand, the big companies, the larger companies, with the means that we have at hand. So there's guarantee schemes, loan schemes. There is a huge fund for very large companies. Lufthansa tapped it with 9 billion. Three other companies have used that fund so far, which is directly governed by the government, by the federal government. But there's this black hole of small companies and entrepreneurs. Small companies and entrepreneurs find schemes as well, but only for their business costs, not for their livelihood. And that's a huge issue now. They're running out of reserves on their livelihood savings. They're tapping their pension schemes. And this is a huge issue. There is no such thing like a self-employment income support scheme as you have it in the UK. It's not existent in Germany. So for millions of entrepreneurs and as many small businesses that are not affected by a duty to file, And at the same time, most of the creditors you have today do not file. So especially tax authorities who would usually file if you don't pay them, they do not file at the moment. So even if you have the duty to file, either non-existent for these type of companies or debtors, or a very precarious situation for them, they wouldn't show up in the insolvency court as well, because they can still manage in some place, in some way. So they managed to negotiate with their creditors still in 2020 at least. They still managed to find some funds and get supported by their husband or their spouses. So they're in a very difficult situation, but they do not yet show up in the statistics because they do not file for insolvency. All of this will change eventually. This kicking the can down the road will not last for much longer, especially in Germany. It will probably hit a point somewhere next year, probably behind the election, after the election. And unless there is a solution to the pandemic in time, with whatever solution there will be out there early in 2021 or mid 2021, Germany will hit this cracking point, and numbers will go up. It will not hit those companies, many of the companies that we've discussed earlier, who will be well advised and well provided with liquidity and using the new good law that we have. But there will be a lot of cases under this level, small businesses, entrepreneurs, who've struggled so far with their small hotel or their small travel agency or a restaurant or a corner shop, and they will run out of money at any time this month, and they're struggling really. So there's big need to cover that, and there's currently a discussion, and I support that a lot, to have something like the British support scheme for these kind of entrepreneurs, which give them a little more breathing space. But it doesn't change that we do not have a special, very good working solution for this interim period so far. We simply hit it with money because we can. As we heard earlier, we've had a very good budget and we have reserves in our state funds. But as soon as that ends, we run out of time. So we need the pandemic to end soon, to leave the interim stage soon, in order to survive it in the manner we just do. And that's the basic, dark corner of the German situation as I see it so far.
Thank you a lot, Stefan. To pick up your point about the interim phase, basically, am I right in concluding that, assuming counterfactually, that Germany had already implemented the restructuring directive, that is to say, we would have some form of preventive restructuring framework in place, you would advocate letting those firms now access this process and stop with the massive bailout schemes to help them continue operating?
To be more specific, and that hits one of your questions that you started with, I think it would help a lot those who already know that their business model is working this year and the next year, who can find investors in the market who have trust in their business model. And then you have a good negotiation, and you have support by the new scheme, the preventive restructuring scheme, if you hit a roadblock with some creditors. I'm not sure that the new framework would actually help much those businesses who are affected by COVID due to uncertainty, due to the fact that they don't know whether they have a good business model in 2020, probably not, whether their business model will work better and create revenue and a positive outcome in 2021, which is far from certain for many. If you look at Lufthansa, it starts with Lufthansa, it goes through all the travel branch, hotels, travel agencies, cruise ships, service providers. And for them to bring them into a restructuring might not lead very far, because you don't have a clue whether their business model will be good in 2021 and will actually be good again in 23, 24, 25, whatever the new normal looks like. You don't know whether people will fly as much again as they did before, or whether they will go on a cruise ship again, or use your hotel as much as they did before. So these very basic functions in a restructuring and an insolvency to test the viability of a business is difficult due to this uncertainty in this interim period, because we don't know the new normal and whether it will be the old normal. So I think it needs more specific tests. It needs some ways to hibernate if necessary, and it needs some tools to leave the old business model behind if you need to. And for that, a restructuring can be good to reinvent yourself. But the magic wand, magic wand, I guess is the word. The magic wand would be to allow that, to give options to entrepreneurs to change, to leave it behind, because they lose trust in their old business model, which means to be able to close it down and have a debt discharge if necessary, or to have a restructuring that is affordable and feasible, to reinvent, not only leave the debt burden behind, but to reinvent the business. And for the latter, the new good law can of course help.
Yeah.
The question, if I may jump in here, is to me if businesses like those you have mentioned, the smaller businesses, be it a restaurant or a hotel, not a hotel chain, but an individual hotel somewhere, not in a core area or whatever, if the new restructuring law is really a tool that helps these companies, I to some extent doubt that, because looking at the 100 sections in there, it is quite a substantial exercise. That's why Christina and I are so happy about it, I think. But at the same time, you don't just need lawyers. You need accountants, you need valuators, whatever experts to really come up with a proper plan that really enables a proper restructuring. That's the one where the court is involved. So another layer of complexity, which in generally, as I said, I really very much appreciate this new law, but I think it's not exactly made for the very small entities or very small companies that you were mentioning initially. But I leave that here for discussion. Maybe you have other thoughts on that, but to me it looks like more a tool for medium-sized and bigger companies, corporates, and the like.
Christina, what are your views on that specific issue, namely whether the new law is a good instrument, not just for the large corporations such as Lufthansa and the likes, but also for the small and medium-sized enterprises, for which Stefan has argued there's no scheme in place to help them financially to weather the storm in the coming months?
Well, I believe that we should not forget the preventive restructuring framework is just an implementation tool. So the solution must be worked out by the debtors themselves. So the actual business plan must be presented to the creditors, and there needs to be a viable business plan, because obviously any business needs liquidity going forward. So you would need to have a bank, a financial creditor on board to support whatever kind of business plan is presented. So it's just a tool to implement a solution if, for example, if it's not possible to be implemented in an out-of-court scenario, consensually with the support of all existing financial creditors. And taking this into consideration, I think also for the entrepreneurs and the smaller businesses out there, they might have to reinvent themselves, and they might have to readapt to the changed environment, to the new normal, as Stefan just said, because definitely the business model will have to change for the various industries, and also for casual dining. If you take all the restaurants, they would have to develop new models for dining going forward. And this applies to a theater and cinema and whatever it is, leisure. We will need to focus more to become more creative with solutions, but not so much with implementation tools, because it won't help if there's nobody out there to actually support, to provide funding. And this is why I'm also looking at the new restructuring framework from a creditor's perspective also very much, because they are the ones who would need to support the solution which is being found. And it might be a good idea to cram down creditors in the restructuring plan but we should not forget to give them sufficient power also to be able to influence the process, because they are the ones, they need to fund this business going forward. So I'm certainly a little bit concerned when it comes to treatment of creditors' rights in the new restructuring framework. And yes, it is necessary to give the debtors sufficient powers to push this process through, if necessary, against the will of minority creditors. But we should not forget the majority of creditors, because they will need the support.
Thank you. I should like to pick up another point that Stefan made about the alleged lack of an existing effective tool to support this, in particular small and medium-sized enterprises in these times with sufficient cash. Now, Germany, as I said in my introduction, is a federal state, so there are a lot of measures on the federal level, but there are also measures that have been taken and are implemented on the state level. Now, as far as livelihoods is concerned, that sort of regulatory competition is clearly visible. Now, what about commercial law? How do you assess what states, individual states like Bavaria or others, of course, have done? And is that not something in particular that would lend itself to addressing the issue of funding local small and medium-sized enterprises? So do we see initiatives or measures implemented by states to address that problem in particular?
We do. The problem is, and I did some research on it because I only knew it from firsthand from the state I live in, which is characterized by a rather small business economy. So there's no big major even foreign company here, at least not many. There's Leuna and everything, but it used to be an industrial core, and it's Eastern Germany, so it is now modern industrial core, which means not much of the old businesses here. But coming back to your question, what I learned from the research is, and it's the same here, is that we have state-based funding initiatives as well, loan programs, subsidies programs for targeting the local economy, which is often a very branch-oriented and sometimes a small business-oriented approach. But it doesn't have a legal condition to be either local or small or in a specific branch. It only means that you need to demonstrate that your revenues went down due to COVID, which means that you need to demonstrate that your revenues went down in 2020, usually beginning in March. So that's the only test. But in promoting these local efforts, our state governments, of course, highlight that this is for whatever is typical for the state. So in the northern states, you find that this is meant for local hotels, the holiday branch, travel. In rather southern states, it might look a little different in the overall promotion. But if you look at the hard terms, it's the same as the federal programs. It's expenses, business expenses, but it's not livelihood of the entrepreneur, or the entrepreneur being the sole shareholder. So it's only for continuing business expenses to keep these expenses paid, so to not have a domino effect. And you can apply at the state level as much as on the federal level, and they have rather strict caps to some extent, and you can add those programs if you can. So there is no coordination as far as I could see, and they extend it by way of a subsidy or by way of a loan. And if they extend it by way of the loan, they are competing creditors in case that there will be an insolvency. It's always handled through state-owned banks, so it's the KfW for the federal level, and the state-owned banks on the state level. But as far as I can see, there is nothing like coordination. It's more like a role model, and we do the same for us because we want to do something as well. But it's not like filling gaps that the federal state leaves on a state level. But I might be mistaken, and I hand it over to my colleagues.
I would agree that there is probably a very low level of coordination amongst the different, the state level on one side and the federal level on the other. From my personal experience, we've seen a lot of cases where, for example, it wasn't possible to obtain KfW financing, and then we moved on to apply for state guarantees. State guarantees are available in the different states depending on where the business has its registered seat and where the employees are located. The state would probably consider provide state guarantees for new money, which would have to be provided by the banks of that company. So that's something we have seen. Subsidiary to KfW financings, but having said that, I wouldn't say that they exclude each other, although I think it's not stipulated anywhere. It's just a matter of how debtors do approach these situations. They normally would go for the larger KfW financings in the first instance, and if that is not available because it is a private equity owned company, which where for example the shareholders are not prepared to give further financial support to that company. In these situations, KfW may not be available, so we would be moving on to the state level.
Yeah, fully agree. Maybe one of the things that does distinguish the state level or the federal level is maybe the size. So the federal government has provided programs, be it under the Economic Stabilization Fund, or the bigger KfW programs that in terms of size by far exceed what you would get on a state level. But I agree there are a number of overlaps, and we had the same experience with clients, and especially in April and May when the need was very high and things turned out to be a bit bureaucratic, perhaps at that time, at least with KfW. We went back to but that's maybe a personal thing here. Here there were quite pragmatic people on the LFR level, so the state-owned bank, and so that was a lot easier to get money there and to get the money quick, rather than going through the KfW process. On the other hand, with some more complex and probably higher amounts being involved, restructuring is now going on. We do see a lot of KfW stuff. But clearly, I mean, for the very big cases, I think Horst, you've mentioned the Lufthansa rescuing earlier this year, where the Economic Stabilization Fund came in. We actually at Hogan Lovells advised the German government on that program, so that was a huge project, these 9 billion you were mentioning, but that's clearly something, I mean, something you won't get on the state level, because it includes taking over and actually participating in these distressed companies, a structure that we already know from the financial crisis, where you will remember under the bailouts, the state took over participations in various banks. And so this very same concept was then implemented here, but this time not just for the financial industry, but for basically the whole economy, and I think helped a lot, at least for situations like Lufthansa was in the other day, or maybe still is.
Thank you. So there seems to be at least a potential benefit for local measures under certain circumstances, especially with respect to the investment of local banks to local businesses' problems. Now, let me pick up two questions that have come up in the queue function of this event, and give you an opportunity to respond to them. And actually, given how time has progressed, this is probably going to be your final word, so choose your words carefully. So the one question relates to the new restructuring law that we also have been discussing already, and I take it from your previous interventions that you're all in principle sympathetic to this new restructuring regime. Now, the question by Tabor Taiti asks you what gives you reason to be optimistic about this law against the background of the German insolvency regime, which now is in force since about 20 years. And when it entered into force, it was greeted with great fanfare, and everybody hoped that this would be the new German Chapter 11. And it turned out that it wasn't a really good instrument to restructure distressed enterprises. So what makes you so optimistic about this new regime? That's the one question. And an aspect to this question comes to us from Karen Oni. She inquires about the protection of fresh money that already has been mentioned by you, Christian, in one of your answers, whether the protections that the COVID legislation foresees with respect to new financing is sufficient, or whether you see reasons, or others see reasons, to amend these provisions and maybe come up with something else. So maybe Christina goes first, and then Christian, and then Stefan.
Yes, I would like to start with the first question. So what makes us optimistic about the new restructuring framework? I think it's digital. It can be, for many businesses, it can be the last alternative before entering into insolvency. And as a restructuring advisor, we typically try to avoid insolvency situations. It's not always possible, but insolvency filing and insolvency proceedings have proven very often to be value destructive, to have basically detrimental effects on the operational business, on customer contracts, supplier contracts. And it's very often combined with unforeseen developments, unforeseen events, triggers of termination of contracts. So I would always be looking to avoid an insolvency scenario. It can prove to be very efficient for certain situations. So the exceptions confirm the rule. But for example, there have been many large insolvency cases which have been very successful, where the business has either been sold or restructured by way of insolvency plan. So I wouldn't categorically exclude it as an option, but in the first instance, I think an out-of-court restructuring, and when we're also looking at other jurisdictions, at the Chapter 11 proceedings, at the UK English scheme of arrangement, which has been used over many, many years to successfully restructure businesses and groups of companies. And I'm not talking about only individual companies in Germany, I'm talking about international groups of companies which don't have a chance to survive in an insolvency process, because we would be faced with multiple local insolvency proceedings in many jurisdictions, which could not be run in parallel, so it would be very difficult to coordinate. So this is why this proceedings will allow businesses to continue operating, to right-size the balance sheet, and to keep on moving. Yeah.
Thank you, Christina. Christian?
Right, yeah. I think you're right, Horst. We had great expectations with regard to the insolvency plan when it came into force. We realized there were some flaws in there. Some of them were cured in 2012 under the revised insolvency law. We introduced the possibility of debt to equity swaps, a key feature that existed already under the US law, but not under the initial insolvency plan procedure. So it improved a lot. The new law, in many respects, is very much similar to the insolvency plan. That there are, of course, differences in details, like the majorities in the groups, but the principle or the concept as such, that you divide creditors into groups, give them voting rights, and basically be the one who is in charge of this process is very much similar in under the new law. The key difference to me is, and that's the practical experience I think that Christina has also described, the mere fact that you end up in insolvency proceedings and you are using the word insolvency is something that scares a lot of business partners. I recall I think one of the first insolvency plans we made back in 2012, right after the new law or revised law became effective. We had a retail chain and we had suppliers in Italy. And when they heard the word insolvency, which is part of the insolvency plan, they were extremely scared, and it was very difficult to kind of make them cooperate here. And I remember the other day, I think Horst was on the panel, we were sitting on a couple of years ago together. We had one of the restructuring advisors there. He suggested, let's skip the word insolvency plan from the German law and call it an I plan. That is much more popular whenever you have an I in front of something like, the iPhone and iPad, have an I plan. And that was something, I think he was right. The mere fact we are dealing with insolvency is not helpful. And the new law, be it very similar to the existing insolvency plan proceedings, removes that, and you are outside insolvency proceedings. That makes me very optimistic that this will be seen as something which is not necessarily linked to the end of the story, but as indeed a proper tool for a fresh start. Regarding your second question, I think I've shared my view already on the fresh money, that I see the necessity of more flexibility there. And so I like to, end my thoughts with that fresh start idea, and hope that this will become true then going forward and helping people in their current difficult situations. Thank you.
Yeah, two things. First question first is, how do we support financing troubled businesses? And the question is practice and jurisprudence. So there's not much in the law for interim finance, and it has established a very good practice of interim financing measures in insolvency proceedings. We will see how this works in preventive frameworks where there's no insolvency, no uniform proceedings, so there's no proceeding at all. So finance needs to be something like finance from the market or stakeholders. And then there's jurisprudence telling you that as long as you do that in good faith of a successful restructuring, and there's not only faith but some substance to it, you're safe in case it fails. So there is existing jurisprudence, which is the background why we do not try to get this into the law specifically, because we feel like it's well established out there already. Something very unusual for a German legislator, but maybe in this point it's he's right or she's right. The second question is, what makes us hope that the new law will be better than every experience we've had so far with restructurings under German insolvency laws? I guess the answer is very simple, because at least from a German perspective, and probably from an English and US perspective, German law has always tried to copy successful models from abroad. So we copied Chapter 11 when we modernized our insolvency laws. We copied debt to equity swaps basically from English law CDAs when we remodeled our laws in 2012. And we always were behind the show, because the show has moved on to schemes, and we just initiated a law reform that established CDAs. And so I guess the big chance we have now is to be ahead of the group, or at least in the top of the field. So we're not lacking behind this time. We try at least to be modern, ahead of the group, at least in the top of the group, and that makes us quite optimistic. Of course, there's the need for courts to be able to handle it, but I think in some way, in some courts, this will happen well, and practice will figure out where that will happen and find ways to get there. So I guess there's a reason to be more optimistic this time than 20 years ago, or maybe even 8 years ago.
Thank you. This is very optimistic as an outlook. Now, in a sense, what we are witnessing right now is something really special. We are witnessing the making of a very massive new law in the eye of a storm, of a brutal storm. And it's kind of playing for time, right? So maintaining the businesses afloat until the new law has been set up. Now, in a sense, I share your optimism as far as lawmaking capacity is concerned. Those of you old enough today will remember that about 30 years ago, Germany shut down one legal system in the former GDR and transformed the whole legal system into the West German legal system basically overnight. And it worked relatively smoothly. So this was a law that didn't have just 300 pages, as Stefan mentioned, but thousands of pages, including annexes. So the bureaucratic capacity and the lawmaking skills of Germany, I wouldn't doubt. The question is Germany going to get it right on the merits? And here I have a different perspective, I should say. I fear that what we are going to see is a graveyard for zombie firms that all assemble within the framework of this new, quote, restructuring regimes. 99% of those firms probably should be liquidated rather sooner than later, but they will linger on. Maybe I will be proven wrong, I hope so. Experience and my own history as an academic and policy advisor suggests otherwise. Thank you very much to you all. Thank you very much to making these wonderful presentations that helped us understand much better what's going on in Germany and to what extent Germany may be successful, actually even a role model maybe for other jurisdictions and where the problems are. Thank you to everybody who has been listening to us today and putting questions to the speakers. I think we had a very interesting afternoon, and we will certainly be taking everything we heard today into account in the further work that we are going to do on this project. Kristin?
Thank you very much, Horst, for chairing, and thank you very much to the three speakers for fantastic presentations. I could ask 17 questions following what's been said, but I won't because we're out of time. But thank you very much. It was very illuminating and thought-provoking, and we're very grateful to you for doing it. Thank you. And thanks to everyone for joining. Bye, everybody.
Thank you. Thank you very much.
Thank you. Bye-bye.
Thank you.